Thank you very much. Your Eminence, ladies and gentlemen, colleagues. My colleague, Judge Prince, and I will share this talk, and we want to tell you about this new United Kingdom law, which Alison Saunders has spoken about. The Modern Slavery Act came into force last year. I retired over 10 years ago from being a judge, but am now an independent member of the House of Lords, our Senate, and had a lot to do with the wording of the new law. So I thought I would tell you something about the main points of our legislation. Scotland and Northern Ireland have separate jurisdictions, but the Modern Slavery Act is also part of their laws. The Modern Slavery Act brings under one umbrella all the different parts of human trafficking and slavery, sexual exploitation, servitude, and forced or compulsory labor. The consent of the victim is not a defense for the human trafficker if the offense is proved. We apply Article 4 of the Human Rights Convention. The Act increases the imprisonment of human traffickers up to life. It extends the jurisdiction of the United Kingdom courts to those who traffic or enslave overseas. The court may make a reparation or compensation order to the victim, though I'm sorry to say, to my knowledge, none has yet been made. A police officer or senior immigration officer may detain a vehicle, a ship, or an aircraft if the person who is the owner, charterer, or has it under a hire purchase order has been arrested for one of the serious offences, and an order for its forfeiture can be made by the court. In certain circumstances, a senior government minister may require a police officer or enforcement officer to stop, board, divert, and detain a British ship where there are reasonable grounds to suspect an offence under the Act has been committed. A foreign ship may be detained if the home state asks the United Kingdom to help in doing it. Alison Saunders has also already told you something about prevent orders, but I'd add just one or two words. The purpose is to prevent any further trafficking offences and to protect victims from that offender. She told you about the various prohibitions, but there's one example which is quite interesting, that 4 Slovakians convicted of trafficking offences were sent to prison, and prevent orders have been made which prevent them, after their release from prison, from going to the area in Slovakia where the victims were recruited, and the Slovakian authorities have agreed to enforce the English court orders. That seems very good EU cooperation. Alison has also told you about the risk orders, which are part of this new legislation. The most important part of the new Act is the creation of the Independent Anti-Slavery Commissioner, and our Commissioner has just spoken to us. I am delighted to be a member of his advisory panel, which is chaired by the Bishop of Derby, who is a member of the House of Lords. Another important part of the Act is the section which protects victims, and I'll tell you a bit about it, although Judge Prince will go into it in more detail. If a victim can show that he or she was compelled to act as a slave, such as a Vietnamese boy locked into a cannabis farm in London, it is a defence to the crime that he has committed, and he should not be prosecuted. And there is also a presumption that a person under 18 is not guilty of any offences which he may have committed. The government has pilot projects providing child victims with child trafficking advocates, which are required under the Act. There are special provisions for overseas domestic workers who've been treated as slaves, referred to earlier this morning. I have to say that that part of the Act has not yet been entirely resolved. The last important part of the Act is the requirement for large companies to make an annual slavery and human trafficking statement to provide some transparency on the supply chains. And we were, of course, told about the Bangladeshi earlier today, about the Bangladeshi building that fell down. And that is one of the areas where this transparency in the supply chains will be so important. We have, in my view, good legislation, and now we have to make it work. Our system of identifying victims is not as good as it should be, particularly for those who come to the United Kingdom from outside the EU. The government is looking to see how to improve the system. There's a lot of work to be done to improve the way we deal with the perpetrators of these shocking crimes and the protection of the victims who come to or within the United Kingdom. But we can now improve the way our courts and our judges deal with these issues.
Please, Judge Christopher Prince.
I'm a trial judge. I deal with many cases involving vulnerable victims of crime. I'm also a pragmatist. Whatever the global scale of the problem, whatever the difficulties there may be in the investigative process, as a trial judge, in common with those others of you here who are trial judges, I know this. It is imperative that there exists a trial process in which vulnerable victims may engage. I shall be speaking as to how, in the United Kingdom, the judicial approach to the conduct of criminal trials involving all vulnerable witnesses, be they victims of trafficking, slavery, or sex crime, has radically changed. Our legislature and judiciary have introduced measures to enable all vulnerable witnesses to give their best evidence. We've recognised that victims of crime can give evidence at trial without distraction, fear, or anxiety. The quality of their evidence will be optimised and justice will more likely be achieved. An incidental benefit is that if a criminal justice system is respected by its citizens, it serves as fair and humane and recognises doing so in its treatment of victims, those victims are more likely to come forward to seek justice. In any trial involving a young or vulnerable victim, the trial judge in England and Wales may order that a combination of the following may apply. That the judge and advocates remove their wigs and their gowns, that the public gallery be cleared, that witnesses shall be permitted to give evidence in court from behind a screen so they cannot see and are not visible to the defendant, that they be permitted to give evidence by live television link from a room other than the courtroom, that their evidence consists of a pre-recorded DVD interview undertaken with the police hours or days after they first contacted the police, that cross-examination by the defence be by pre-recorded DVD conducted soon after they're first spoken to, that a professionally trained intermediary accompany the witness throughout their evidence to advise the court when questions are inappropriately complicated and to assist the witness to understand questions and carefully formulate their answers, that the defence shall submit in writing all questions they wish to put to the witness and the trial judge will edit and limit these appropriately, that the duration, content and manner of delivery of questions will be strictly controlled by the trial judge, that aggressive questioning will not be permitted, that leading or complex questions will not be permitted. This modern approach to the treatment of vulnerable witnesses has recently advanced further with the introduction of what we now refer to as remote link sites. The first site opened in Durham in July 2015. It is some miles from the court building. It provides a comfortable, calm, reassuring, supportive environment with trained staff, soft furnishings, neutral decor, with tea because we are in England, coffee, hot chocolate, biscuits and computer games for young people. The site has three core elements: a medical examination room and scientific evidence gathering suite, a comfortable interview room equipped with cameras to record victims' evidence to DVD for use in evidence, and thirdly, a live camera television link to the courtroom. By way of a typical example case, a female victim who telephones the police will be taken to the site for medical examination and then driven home or to a place of safety. A day or two later, she'll be collected and taken to the site where she'll be interviewed and her evidence recorded onto DVD. Some weeks later, on the day of trial, her pre-recorded evidence DVD will be played to the jury and she will return to the remote site with which she is now familiar and where she feels at ease to answer questions over a live television link to the courtroom. We have therefore arrived in England and Wales where the position where vulnerable victims of crime, such as slavery, trafficking and sexual abuse, can participate fully in the criminal justice process without having, as in the past, to enter a hospital, a police station or a court building. The sites have got the further advantage that they can link to any courtroom in the country, so victims do not need to travel from safe accommodation to attend at trials. Those most likely to be victims are generally younger than the judiciary. The younger generation is perfectly accustomed to and comfortable with communicating face-to-face via social media. It may be radical to some members of the judiciary to receive evidence in this way. It is rarely radical to victims. The official evaluations have been universally positive. Those of us who often conduct trials involving vulnerable witnesses see how very effective these measures are on a daily basis. They work. Having explained the measures, I should also say that we've introduced, to assist vulnerable victims to prevent their best evidence at trial, we've added that if a defendant pleads guilty or is convicted following trial, victims are invited to read aloud or submit in writing statements describing the impact the offence has had on them. For a variety of reasons, including assisting recovery and knowing that their suffering has been recognised by the court, victims very much welcome this opportunity. In determining and passing sentence, the sentencing judge will always take account of and refer to the impact on victims. The Lord Chief Justice of England and Wales asked that I tell you of the work undertaken in our jurisdiction on behalf of vulnerable victims. Our judiciary is very proud of what has been achieved to date. There is still more to do. If in your respective jurisdictions you have introduced measures which I've not mentioned, I should welcome learning of them in the time this summit affords us for informal discussions, so we may consider adopting them in our jurisdiction. Similarly, I'd be pleased to discuss in more detail the measures I have described. As with Kevin Highland, I wonder if I may close with a quote. That great Italian author, Primo Levi, wrote of victims in If This Is a Man, "If we speak, they will not listen to us, and if they listen, they will not understand." Victims have been speaking to us in courts for years. We have always listened, but perhaps only now the victims can tell their stories fully and clearly are we ensuring that they are not just heard, but also understood.
Thank you very much.